Imagine coming home from a long vacation, unlocking your front door, and finding a complete stranger sitting in your living room. When you ask them what they're doing there, they don't run. Instead, they hand you a piece of paper and claim they have a lease. Naturally, you call the police. But when the officers arrive and look at that piece of paper, they tell you they can't make an arrest. Even if you know the document is completely forged, the police will tell you their hands are tied, because legally speaking, it's a civil matter. This incredibly frustrating response comes down to the strict boundary between two legal categories, a trespasser and a squatter. A trespasser is committing a crime by breaking and entering, giving police the immediate authority to arrest. But a squatter asserts a right to residency. Once they present a lease, the dispute crosses into civil law, freezing law enforcement's authority. Simply asserting that they live there creates a legal force field around the occupant. It shifts the entire conflict out of the criminal justice system and dumps the burden entirely onto you. In the American legal system, civil law handles private disputes between individuals, not offenses against the state. This means the government cannot use the threat of jail time to resolve what looks on paper like a disagreement over a housing contract. To get your house back, you are forced to become a plaintiff in a lawsuit. You have to hire a private attorney, pay out of pocket, and petition a judge for a formal eviction injunction. Looking at this timeline, you can see the stark difference. Criminal removal happens in a matter of hours. Civil litigation requires navigating court backlogs that drag the process out for 6 to 12 agonizing months, while attorney fees keep climbing. For that entire duration, the occupant gets to live in your property completely rent-free, while you bleed cash trying to navigate the legal system. The person occupying your home is relying on exactly this. They are actively weaponizing the structural slowness of the civil courts, using the rules of the system to exhaust your time and money. By 2024 and 2025, this tactic had become an epidemic. The step-by-step playbook for printing fake leases and exploiting civil courts went viral online, pushing the system to a breaking point and forcing state legislatures to step in. The response arrived in a wave of new state-level legislation rolling out through 2026. States like Texas, Indiana, and West Virginia drafted targeted bills aimed specifically at the squatter loophole. These laws execute a sweeping statutory override, systematically dismantling the ancient common law loopholes bad actors relied on for decades. This flowchart illustrates exactly how they do it. The new laws physically yank the act of squatting out of the congested civil court pipeline and drop it directly into a high-speed criminal pipeline, where the threat of incarceration is back on the table. By recategorizing the offense, lawmakers have finally given police the explicit statutory authority they need to intervene and take action on the spot. In West Virginia, for example, the state's Stop Squatters Act now explicitly defines this behavior as a crime, allowing the government to punish occupants with actual jail time. Meanwhile, states like Texas and Indiana have created entirely new administrative procedures that establish a fast-track system for legitimate property owners. This fast track completely bypasses the local civil court docket. Once a homeowner files a sworn, verified complaint, sheriffs are empowered to physically remove the unauthorized occupants within 48 hours. The homeowner no longer has to stand alone as a private plaintiff navigating a costly lawsuit. The state steps in and enforces their property rights for them. These mechanics treat the theft of a home with the same urgency as a robbery in progress. It immediately neutralizes the single biggest advantage the squatter had: time. But this rapid response creates a serious risk. What stops a malicious landlord from using this new criminal shortcut to illegally bypass the courts and kick out a legitimate rent-paying tenant? In fact, this risk is exactly why police avoided these disputes in the first place. Officers were terrified of violating a legal tenant's 4th and 14th Amendment rights against unreasonable seizure and lack of due process. Under Title 42, Section 1983, citizens can sue government employees who violate their constitutional rights under the color of law. Mistakenly removing a legal resident triggers immediate federal liability and massive civil lawsuits against the officers. Therefore, for these 2026 laws to actually work, lawmakers had to strike a very delicate balance. They needed to give police the power to act rapidly, while ensuring that innocent tenants weren't stripped of their constitutional due process. State legislatures solved this massive liability problem by embedding high-stakes financial traps directly into the new fast-track eviction laws. Take Tennessee's Public Chapter 1009 as a prime example. Under this law, if a property owner lies on their verified complaint and wrongfully removes a legitimate tenant, the landlord is forced to pay the tenant triple the fair market rent, plus attorney fees. This financial penalty perfectly balances the scales. It empowers police to act swiftly against true squatters, while simultaneously terrifying any landlord who might even consider abusing the fast-track system. By formally reclassifying the act of squatting as a criminal offense and building in these heavy financial penalties for abuse, the 2026 legislative wave has effectively closed a centuries-old loophole in property law. The viral playbook is broken. The legal vacuum has been filled, shifting the balance of power squarely back to property owners and ensuring that a private home remains an untouchable sanctuary.